Let's start with the first question. So what are European interests and expectations from this free trade agreement with Australia? If we look at official releases, Europe expects that this FTA would increase trade in goods by 37% and trade in services by 8%. Well, actually, they had very good results after FTA with Korea, so they also have high expectations with Australia. Now, the sectors that they think will be positively impacted most are machinery and appliances, chemicals, motor vehicles, food and drink, electronic equipment, metals. These are the areas in which Australia and Europe have already been conducting trade. Now, what about creative industries? Apparently, they are not on the list. However, they are also not at the bottom of the list. Why? Because Europe has quite strong creative industries. They contribute 5.3% to GDP and employ 7.5% of all persons employed in the economy. These are rather high numbers and actually much higher than Australian creative industries. I think Australian creative industries contribute 3-point-something% to GDP. Europe is the largest exporter of creative industries around the world, if you take the entire Europe. And some sectors have a really great contribution in exports, like fashion goods account for 12%, and high-end industries make up to 18% of entire European exports. So keeping in mind that potential that European creative industries have, of course, the European Commission has said that one of the goals is actually to expand international reach of European creative industries. Now, in this context, what's the role of IP here? I think all of us know that government believe that IP is instrumental and copyright is instrumental in ensuring that creative industries flourish in Europe and outside. And that's why Europe has IP enforcement strategy in third countries, where they try to make sure that there is as much IP enforcement in third countries with which they trade as possible. Even if some academics may doubt or may question this, saying like, well, it's not sure how much stronger IP laws lead actually, to which extent they lead to more productivity in creative industries. Governments still believe this, and that's why it's likely they want to have powerful IP provisions in their free trade agreements and also enforcement of these rights in trading in their partners with whom they trade. Now, so we know that Europe has strong creative industries, that they want to export them, and that they think that strong IP laws and enforcement are instrumental in achieving these goals. How does this reflect? How has this reflected up to now in the recent FTAs that EU signed with other countries? If we look at the Korean and EU FTA, which became effective in 2011, so quite a number of years ago, actually that was the first new so-called new generation free trade agreement between Europe, that Europe has signed with some country. It was the first agreement that contained a very elaborate IP chapter with a number of copyright provisions, and Europe had very high ambitions to set not only minimum IP protection standards, but so-called TRIPS Plus and even ACTA Plus. Maybe not all of you are familiar with these agreements. So there's TRIPS agreement that sets certain international standards for IP enforcement, and there was some agreement so-called anti-counterfeiting trade agreement that was signed among a number of countries, but eventually, well, it failed. Now, in this agreement, Europe was quite successful in negotiating standards that were TRIPS Plus and that required Korea to amend their copyright laws in some regard to so to say, strengthen copyright, in order to strengthen copyright protection. For instance, Korea had to extend their copyright protection from 50 years to 70 years after the death of the author. They had to introduce the right to television broadcasters to control communication of broadcasts in public places. They had to prohibit retransmission of television signals over the internet without authorization of right holders. Now, Europe had actually higher ambitions than that. They wanted Korea to introduce even further standards of protection, like they wanted to Korea to introduce the right for performance and phonograph producers to require remuneration when music is being played in cafes, restaurants, and other places, but this has not been achieved. They also wanted Korea to introduce artist resale right, but the only thing what they managed to agree is that Korea will revisit this question, the need of such a right 2 years after the agreement comes into force. So they don't have such a right. So they had some partial success, but essentially they managed to some extent export their European laws into Korea, you know, to reach at least some extent European standards. Now another example is Canadian FTA, Canada-EU FTA, where Europe again started with high ambitions by kind of strengthening copyright protection and implementing European level copyright protection standards in Canada. And in the leaked draft of 2009, the FTA had required, so to say, Canada to extend term of copyright protection, to implement new rules on internet provider liability, to implement criminal sanctions for some copyright infringement, new rights for broadcasters and artists, and so on. However, the intentions, these goals were not achieved at the end, and if we look at the final text of copyright chapter of free trade agreement between Canada and EU, actually does not contain any copyright provisions that would require change of laws either in Canada or Europe. So they were heavily watered down, and you could say that European Union failed in their attempt to increase copyright standards in Canada. Now, what are the reasons of this failure? There are probably some national and international developments. So at the time of negotiation, Canada was running their own copyright reform, where public has raised concerns about the strong copyright protection, and Canadian government was not willing actually to strengthen it. In Europe, meanwhile, the ACTA agreement, which I mentioned before, was rejected by European Parliament, which meant that Europe had to withdraw back some of the requirements from free trade agreement that were controversial in Europe, such as criminal sanctions. Also, European Union at that time, they gave preference to stronger protection of pharmaceutical patents and geographical indications, FTA, and said, well, we can abandon some of requirements as far as copyright is concerned. So, and that led to kind of weaker copyright chapter in Canadian European FTA. Now, if we look at these two FTAs as an example, and also some others, what are the general trends that we could kind of draw from EU trade deals with other countries? So the first trend is that EU tries, similar like US, to export their copyright standards to other countries. And the second is, well, their success rate is different in different countries depending on national and international political situation, and how they balance different IP interests in different countries. So if we look at these trends, so what can we expect in Australia? Or what is there for Australia to be afraid of as far as copyright chapter in future FTA with Europe is concerned? Now, probably first, it's quite easy to say that our European FTA won't be as scary as was FTA with US, which required a lot change in Australian copyright law, and Australia during the last few decades already implemented a number of rights that are so important for Europe, like moral rights, performance rights, resale royalty right. Term of protection for sound recordings is already 70 years, which was just relatively recently introduced in Europe. Retransmissions of broadcasts over internet already protected in Australia under Australian-US free trade agreement. Playing recording in public spaces like cafes, restaurants, which was, let's say, an issue in Korea, is already licensed here in Australia. So actually there is nothing much for what Europe might want to fight for here in Australia. The main difference, I think, between the countries is copyright exceptions, but this is not the issue that is normally addressed in FTAs. Nobody really cares about exceptions, harmonizing exceptions. Now the issue that might attract some attention is actually intermediary liability. And why this, and this is what I wanted to focus on in my presentation, is one first thing which all of us IP lawyers, especially copyright lawyers here, knows that Australian rules on safe harbors have some issues. They do not extend to commercial service providers, and despite of recent amendments of Copyright Act, they still do not apply to commercial service providers, and Europe may say we don't like it. But what is even more important is some new legislation that is pending in Europe as far as internet service providers are concerned that set filtering obligations on such services like YouTube. So let's take a look at this pending European legislation and see what would happen, what effects it might have on free trade negotiations with Europe in case it's adopted. So this proposed directive on copyright and the digital single market is on the table since 2016, and it has a number of provisions that include exceptions to libraries, exceptions for text and data mining, extended licensing of out-of-commerce works, and other things with which copyright lawyers are certainly familiar. Now, all of them are not that relevant for our purposes because these things are not normally addressed in a free trade agreement. Exceptions is not normally regulated on bilateral or even international level. Now, there are two things, however, that might be relevant. This is very controversial, Articles 11 and 13 of the directive. So Article 11 of the directive introduces a new right to press publishers online. What's the problem that it's addressing? So press publishers or newspaper media publishers have been complaining that, well, they lost a lot of revenue with the digital disruption, right? And now we have social media platforms and news aggregation services like Google News or social media platforms like Facebook that are actually disseminating news by linking to them. They make profits from that indirectly, but they don't share profits with news producers or press publishers. So the research shows that I think in Europe around 40% of users don't click on those links anymore. They're satisfied by just looking through the titles, which means websites, newspaper websites, they don't get traffic, they don't get revenue. And the proposal that is currently being discussed is that press publishers would be given additional right that would enable them to require such services, social media sites and news aggregation services to pay remuneration when their news articles are being linked to, or so to say, disseminated. Of course, this has caused a lot of criticism. It's being called link tax. They say this will stifle, this will make linking illegal online and stifle freedom of speech and freedom of expression. But the article is still on the table. And the second proposal in the directive, the second interesting provision is so-called value gap, or in other words, it's actually filtering obligations. Now, what's the problem here? There are two problems with which all of us are familiar, is this and the amount of unauthorized content on user-generated platforms such as YouTube or Redbubble, what we have in Europe, is still significant, and right holders have been unsatisfied with the so-called safe harbor schemes that exist that say, well, if right holder notifies the platform has to take down the content, but that's all what they have to do. They don't, if the same content reappears on the platform, you have to again notify, and again download, again notify, and right holders have been complaining that it's a lot of burden for them to notify of each and single upload and re-upload of illegal content. Now the second problem, right hole is saying that such platforms either don't agree to pay any money for use of their content online or pay very negligent amounts. So YouTube is paying, let's say, right holders for the use of their content on YouTube platform, but these amounts are really negligent. And it's very difficult for right holders to negotiate higher royalties. So what European Union has done, they proposed a solution. If you read the article that was proposed, it's very difficult. It's kind of very complex and unclear, and it's difficult to understand what do they mean by that. But essentially, there are two things that, it could be summed up in 2 points. So essentially, it requires large online platforms like YouTube to apply measures such as filtering measures to make sure that if they are informed about illegal content, they not only take it down, but they have to keep it down. So to say, make sure that it's not re-uploaded again. Now, this is not something completely new. YouTube, it's already 10 years as YouTube is running ID content platform, for instance, that enables such right holders to kind of provide information about the content that they own, and then YouTube filters out to make sure that such content is not uploaded on YouTube. And some other companies also, many of them are running another type of measures, like Red Bullet, in Australian company. They acknowledge that they also take measures to make sure that illegal content is not being uploaded on their platform. But now this rule would actually make it a legal obligation to all large service providers to filter out illegal content from platforms with a collaboration with right holders. And also, European Commission believes that this would enable them or give additional negotiating power to right holders to negotiate better licensing deal with platforms and increase their kind of revenue levels for digital users. Now, of course, again, there's a lot of criticism surrounding this article. They say that this will lead to internet censorship. YouTube, American company, will be able to filter out the content, and who knows what they're going to take down and keep down. This would limit freedom of expression, freedom of speech, and so on. However, it's still on the table. And if we look at the most recent developments in Europe, the directive, including those 2 articles, has been approved by Legal Affairs Committee of the European Parliament with some amendments just end of June, and 3rd of July, but I'm not sure, maybe 4th, like just a few weeks ago. However, it was put in front of European Parliament, and the plenary rejected it and sent back for further amendments. And now we are all waiting for September, when the proposal will be again before European Parliament, and see whether they approve it or reject it. Now, assuming that this directive is adopted in European Union, what does that mean for Australia? And how it could affect negotiations between Australia and Europe? Well, we already know that European Union likes exporting their copyright law provisions into other countries. And as one example, more recent example, which I haven't mentioned before, was, for instance, the most recent 2011 directive on which extended the term of protection for for music recordings from 50% to 70%. That particular rule was exported into a partnership agreement with Japan. So what does that mean? That there might be attempts for European Union to request Australia to adopt similar provisions into their copyright law. In my opinion, it is less likely so as far as new press publishers' right is concerned, because this right actually intends to protect local European press publishers, and local news sites in a local European language are maybe of not such a great interest internationally. On the other hand, in Australia, there is quite a minority of Europeans and from different countries, and they may still be, let's say, interested in accessing those European news via different social media platforms and news aggregation services. So we cannot rule out such a possibility that Europe might be interested in exporting this particular new right to Australia too. As far as this intermediary liability or enhanced safe harbors are concerned, I think it's very likely that Europe, which always tries to put intermediate liability chapter in FTAs, could try to export this rule into Australia, because service providers like YouTube or Redbubble, they are international, they serve right holders from all around the world and users from all around the world, and of course Europe might be interested to make sure that their right holders are protected and get remunerated all around the world, despite from which service they choose. Now, that certainly would make happy Australian right holders. Would love such an idea of safe harbors that require intermediaries to filter out illegal content. Users, of course, would hate it. And Australian government, I would imagine, would be really interested to listen. They've been, I think, quite frustrated with those, I think it's over a decade discussion about whether safe harbors, this old-fashioned provision, should be extended or not here in Australia. And they would be willing to see whether this enhanced safe harbors with additional duties on intermediaries could be something, a compromise that right holders and users could agree upon. Now, what it for sure would lead to is a new great battle, and for something that all scholars copyright scholars would have to be involved, get involved again. Well, that's all. Thank you. I'm happy to answer any questions.
Yes. Thank you. I'll just get you.
Thank you for the presentation. Do you think there is real differences in terms of American FTAs and EU FTAs? To me, I think both EU and the US, they need more protection in terms of what you have mentioned, extension from 50 to 70 years, more enforcement. This is one point. What do you think about that? And do you think there are real differences between the two approaches, American? To me, as I said, I think that the end result is the same. And one more thing, when you think about making an FTA, EU FTA with a developed country like Australia, I'm not sure if there will be many changes needed in terms of Australian copyright laws and other developing countries. But if you look at the approach EU will take with developing countries, I think here we will have some more request to make more changes toward copyright laws. So I just want you to compare between having an agreement with a developed country like Australia, and also developing countries, and how copyright laws will be different, and what will be the request of EU in terms of those two approaches. Yeah,
thank you for the question. Well, I should say I'm not really an expert in FTAs and international trade. I know more about copyright and in European laws. But to maybe Professor Rimmer has something more to say about that, I'm sure, not maybe. But trying to answer your first question is, well, I think both US and Europe, they try to export their standards and try to implement so-called TRIPS Plus in the countries with whom they're signing FTAs. But it seems that US is more aggressive. As far as copyright is concerned, maybe, or probably because they have much stronger creative industries with much more lobbying power behind, and they try to implement even higher standards than standards that EU is requesting. also, US seemed to, like at least in the countries I looked at, US was always the first one to come in, and they signed let's say FTA with Korea first. So Europe had nothing so much to add. And then now again, US coming to Australia again, they came first in 2004, was it? When they signed FTA with Australia. So now Europe is coming with, well, they actually cannot require much more than what US required. Just keeping in mind the time gap, maybe there is something else that they can add. So that's my kind of general answer to your first question. As far as FTAs with developing countries are concerned, Europe is certainly they certainly ask different standards from developed and developing countries. They have this how is it called, as a kind of sustainability approach, and they they set different targets depending on the levels of economic development. So you cannot say that they take the same text and say, all countries have to adopt the same text. And if you look at FTAs that they have with the developing countries, they have much less elaborated IP chapter and set much lower goals, which is certainly justifiable. Yeah.
Thank you so much for your presentation. My name is Bikalpa. So my question is, you said the proposal on Article 11 and 13 of the proposal were rejected and to be reviewed. So my question is, like, the European Union, as far as I've read, is much more concerned on, because they have recognized that after digitalization, the digital contents are like really have high potential for economic earnings, right? So when there's a view from the EU of that notion, and then the EU again rejects the proposal, considering like the stance of the current society that the generation is in, because if you try to ban sharing of news or music in social media, then how do you think that would adjust to the present generation's norms?
Yeah, well, I suppose that's exactly why we have such a fierce debate about these provisions, and that's why it's been rejected for the time being, for further awaiting further amendments. European Union is searching for a compromise, right? They have to somehow meet the interests both of right holders, who believe that they need stronger protections online to make sure that that music right holders earn revenue from their music being distributed, and news producers earn from news online, and also they want to kind of meet the interest of users who want to have easy access, and probably they want free access, and the compromise is difficult to strike. So that's why we have that debate, and some argue that the current proposal protects interests of right holders more than the interest of public, but others argue that if you don't protect right holders' interests, then there won't be content online at all, and users won't be happy about that either. So it's a difficult, balancing exercise, like all of exercises in copyright policy making.